Good morning, everyone, and welcome to Husch Blackwell's Labor and Employment Virtual Day. I am AJ Weisler, and I will be your host, and we are so glad to have so many attendees joining us from all over these United States. We're excited to showcase our annual labor and employment update a little bit differently this year. We're going to give you a full day, jam-packed with information, hearing from attorneys from across our offices on crucial legal topics. Feel free to pop in and out for the topics that mean the most to you. And the virtual link available for this application for this morning, you can use to enter at any time. And there will be a different link for part 2, and you can join us this afternoon. An agenda is included on your screen so you can monitor upcoming topics throughout the day. Before we would begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the day. If you have any questions during the webcast, please submit them via the question box. We have attorneys who will respond to those questions today as time allows, or follow up with you after the presentation. A PDF of the presentation and other resources are available in the materials folder. And this program has been approved for HR and legal education hours. So report those hours using the CEU icon at the bottom of your screen. A certificate of attendance with the course numbers will be emailed to you tomorrow, along with a link to the recording of that webcast for watching and sharing. And believe me, you're going to want to watch and share again. Bias and diversity credit has been approved for California, Illinois, Iowa, and Missouri for the diversity, equity, and inclusion topic that begins at 11:10 Central Time. Please participate in the poll questions during that presentation to receive that credit. Toward the end of the program, be sure to complete our short survey. We use that information and feedback that you provide us to determine how to program for our future and to give you information that's going to be most useful for you. That's all the housekeeping items. So now we're going to begin with our presentation. As I mentioned to you earlier, we have an agenda that is packed with topics presented to you by one or two of our attorneys that are joining us, all from beautiful St. Louis, Missouri today, but who have flown here or ridden here from all over the country. And these are all wonderful attorneys. They are fantastic practitioners and advisors, but they're also, most of them, human beings. And so today, before you hear from each of our presenters, you're going to hear a little bit about what maybe doesn't jump off their website profile or their LinkedIn page. And so we're going to go a little bit behind the scenes. And we'll start with our first two presenters you're going to hear from today. They're going to talk to you about wage and hour issues, and they are both excellent, complex wage and hour litigators. And they are Joe Glinius and Scott Myers, both of who work for us here in St. Louis. But what you may not know about Joe Glinius, we'll begin with, is that in his past, before he was a lawyer and the chair of our firm, he was a above average, slightly at least above average baseball player with a bright future. He was so excited about baseball that he actually attended an extra year of high school in order to beef up his resume for college and then the pros. Some of you may be a little worried about having a lawyer represent you who needed 5 years to complete high school, but we assure you it had nothing to do with his academic qualifications, but rather his ability to hit a slider. So the problem, of course, is that Joe, before he could go off on this career, had an injury, as so many young baseball players do. And out of that rose the ash, out of those ashes rose the phoenix that was his legal career. And so to represent and sort of demonstrate to you Joe's experience, I went not to Joe for any sort of information or photographs, but rather to artificial intelligence on the internet. And so here you'll see Joe Glinius, who you're about to hear from, and he is, as AI has demonstrated, a washed up ball player. But he's not the only person you're going to hear from, because you're also going to hear from Scott Myers. Now, Scott Myers, as you can tell from the photograph, that is his real hair color. And Scott Myers has gone off into the world and produced 2 offspring, both of which he decided to pass along his recessive gene to. And so Scott Myers is a true recessive gene proliferator. Now, just to be clear, that's artificial intelligence. Scott doesn't look nearly as good as he does in this photo in real life, and his kids both look a lot better. Actually, we can go ahead and show you. This is his real family, including his poor wife, whose genetic hair color information anyway has decided not to be passed down. So without further ado, now that you know a little bit more about the attorneys in front of you are about to be, I will send it over to Joe and Scott to talk about wage and hour.
Good morning, everyone. Thank you, AJ, for a really confusing introduction. The extra year of high school allowed me to skip law school, which I think works out to everybody's benefit. I'm Joe Glinius. This is Scott Myers, as you probably can tell from our AI-generated photos. We're very excited to be talking to you all this morning about an area of the law that excites us. Probably doesn't excite a ton of people, but it does get a lot of people's attention because it is one of the areas of greatest liability for employers as it relates to employee claims. I'm just going to give us a quick introduction for the day and talk about what's coming. And then we're going to pop over to Scott to get into the substance. But as you can see here, we're going to talk about what is wage and hour, where can you get sued, you got sued, now what do you do, and then pressing issues in today's business environment. We're really going to focus on a practice called rounding, I suspect many of you are familiar with. You'll see here, and for those of you who have attended our seminars in the past, you've heard Scott and me and AJ talk frequently about wage and hour issues. Most of the time when we're talking about wage and hour issues, we're talking about substantive law and how to comply and all that stuff. We don't usually focus on litigation issues. Today, we're going to focus on litigation issues. And the reason we're doing that is because these particular litigation issues really highlight the importance of having regular maintenance on your wage and hour practices. Again, we'll talk about some of the specifics, but most of our clients, or at least a lot of them, find themselves in a position where their wage and hour practices are created not necessarily out of an intentional or strategic plan. Lots of times they just sort of evolve over time, or maybe they were put in place and they've stayed in place for a long period of time. Lots of times they're the result of acquisitions and growth, and they inherit these practices from these legacy organizations. But the problem with that is that they don't tend to get reviewed, and all of the other factors that impact wage and hour compliance, like technology and case law, change over time. And as those things change, whether or not your practices remain compliant becomes questionable, or at least challenged in litigation. So these cases really highlight the importance of continuing to monitor your wage and hour practices, particularly because our clients who don't engage in that sort of regular maintenance, when they do get sued for the first time, they're shocked to find out, justifiably, that the liability for these types of claims is extraordinary. At least 7 figures in most cases, and frequently 8 figures and sometimes even 9. So these are big, important cases and really justify the attention that we'll talk about during today's presentation. I'm going to hand it over to Scott. He's going to talk about wage and hour background.
Thanks, Joe. So a lot of you probably know what wage and hour is, but we just wanted to give a quick idea of what we're actually talking about when it comes to the world of wage and hour. So it's pretty much exactly like it sounds. It deals with the compensation people receive and the hours they work. And the most common ones you probably are aware of are minimum wage and overtime pay. Those are what I would say are the primary issues when it comes to wage and hour that employers are most susceptible to perhaps be having issues with. But this also covers things like 1 day of rest in 7, or how you are tracking individuals' time. Those are all things that fall under that umbrella of wage and hour. But most of the lawsuits that we're handling with, again, today, our focus being on litigation and wage and hour, it's going to deal with minimum wage and overtime pay. The laws that cover wage and hour, the Fair Labor Standards Act, the FLSA, I would hope everyone has heard of that. That's the federal law that's going to apply no matter if you're an employer in California or Massachusetts or Texas. You are going to have to comply with the FLSA if you are the type of employer that it covers, which is virtually everyone in today's economy. But that's not the only thing you have to deal with. And that's what makes this area tricky sometimes, is that you will also have state laws. And state laws sometimes will be very similar to the FLSA, perhaps even identical, but sometimes they will add more protections, or they will be a little bit more difficult to comply with. For example, the FLSA does not require meal periods, but states like California and Kentucky do. The FLSA, under the FLSA, the federal law, $7.25 minimum wage, but other states will have a higher minimum wage. If you're complying with the FLSA, but you're not complying with the state law, you're still susceptible to potential liability on claims. So you've got to make sure that you know not only that federal law, but also all the states in which you have employees, and making sure that you're complying with those laws as well. Okay, so let's say an FLSA case is brought, or a state claim, these can either be brought as single plaintiff or collective and class action claims. This is important because in the world of labor and employment and in litigation, these are the types of claims that are most susceptible to being these collective and class actions. Joe was talking about how that liability can grow into, 7, 8, even 9 figures. That's because of the class and collective action aspect of this. What that means is these are often policies and practices that are going to affect a large group of people in a very similar way, right? If you are paying someone on a certain method or you're using certain figures to calculate your overtime, you're probably doing that for a large number of employers if you are a sizable employer, large number of employees if you're a sizable employer. Whereas types of discrimination claims or wrongful discharge claims, those are more individualized. Those are going to be affecting one person. So here we're talking about these large groups of individuals. For any single person, the claims are usually not that valuable, we'll say, right? Usually the unpaid overtime isn't a crazy amount, but once you start to multiply that across a lot of different employees, that's where that liability starts to grow. So when we're talking about collective and class action, we use those terms interchangeably, but they actually mean two different things. And the collective actions, those are under the FLSA. Those are an opt-in process. That means when a notice goes out that a lawsuit's been filed and then it gets conditionally certified, all of which we're going to talk in more detail about shortly here. So it's okay if some of these terms are a little foreign right now. But what that means is individual employees have to affirmatively opt in to the lawsuit to participate in it. Whereas Rule 23, which covers state law class actions, when the employees receive a notice, they have to affirmatively opt out. Again, we'll talk more about that process, but just wanted to make sure that when you hear collective action and class action, those two things actually mean something different, even though at the end of the day, they are going to function fairly similarly. All right, now Joe is going to talk about where you might get sued for these cases.
Thanks, Scott. All right, so when you're an employer in a multi-state situation, you can get sued in any state where your employee works. The idea is an individual can bring a lawsuit in a jurisdiction where they get injured. So if you are a Texas employer and you have an employee in Vermont, that employee can sue you in Vermont, and that has not changed. That's always been the case. We're not going to be talking about any changes to that today. What we are going to talk about is how the class, or more appropriately, the collective action approach to doing that is in question. I have to give you a little background that comes out from outside of the employment world to really set the stage for this. So historically, it's been very common to see claims get brought in jurisdictions where plaintiffs and plaintiffs' attorneys, more appropriately, feel like the courts and the law and juries are going to be very friendly to their claims. Historically speaking, you all might remember some of the initial billion-dollar verdicts that came out in the tobacco industry were filed in Southern Illinois. There are a couple of jurisdictions in Southern Illinois that are known for being employee-friendly. Well, the cigarette companies, the tobacco companies, are not located in Illinois. But people who smoked and claimed injuries in those jurisdictions in Illinois decided to file a lawsuit, and they were able to file a lawsuit on behalf of everyone in the country. People who were in Illinois, people who were outside of Illinois. In 2017, the Supreme Court ruled on a case involving Bristol-Myers Squibb. I'm sure most people are probably familiar with Bristol-Myers Squibb, but it's a very large pharmaceutical manufacturer. The particular plaintiff, the lead plaintiff in that case, was located in California. Because I'm talking to employers, I know I'm talking to people who understand that when you have employees in California, you are dealing with a very difficult set of laws to comply with, very difficult courts from an employer's perspective, and a very favorable place for plaintiffs to bring their claims. So very similar outside of the employment context as well. There are lots of protections for consumers and for injured individuals to bring these claims in California courts. So Bristol-Myers Squibb has their principal place of business where they conduct most of their executive operations in New York. They are incorporated in Delaware. And the reason I mention that is when you have these very substantial contacts, either where your principal place of business is or your state of incorporation, you can be sued under what's called general jurisdiction, which means anyone can sue you there, whether they were injured there or not. And so, again, neither of those locations, though, are in California. So the Supreme Court takes up the case, and the case was filed by someone who took this drug in California, and it was filed as a class action to represent individuals all over the country who took that drug. The Supreme Court ruled that Bristol Myers Squibb could not be subjected to a nationwide class action in California because their principal place of business is in New York and they're incorporated in Delaware. What that means is, even though that individual who was injured in California and everyone else who lives in California and was injured there could be part of a class action, people outside of that state could not. The practical impact of that is, if you are a plaintiff's attorney and you want to get the really big case that has the really big damages and many times the really big settlements, which lead to really big attorney's fees amounts, you want to be able to bring a nationwide class action so you can have a larger group of plaintiffs with more damages. And if you're limited only to California or any particular state where general jurisdiction doesn't exist, then you're unable to bring that class action. Now, that is a Rule 23 class action. You just heard Scott talk about what that is. So even though that case law now exists at the Supreme Court was not dealing with collective actions under the FLSA. So it became an open question. Would the concept and logic of Bristol Myers Squibb, that case, apply to collective actions under the FLSA? In the federal court system, typically the way it works is cases are not very, very rarely brought initially in the Supreme Court. Most of the time they have to work their way up from what's called the district court level to the Federal Court of Appeals, and then sometimes to the Supreme Court. And so as it relates to whether Bristol Myers Squibb would apply to FLSA collective actions, we needed to go through that whole process. So what we've seen is it's gotten to a few of the federal courts of appeals. There are 11 in the United States that handle the majority of these claims. And each of those courts represents a cluster of states, all geographically proximate. So as of today, the Third Circuit, think Pennsylvania. The Sixth Circuit, think Ohio and Michigan. The Seventh Circuit, think Illinois, Wisconsin, Indiana. And the Eighth Circuit, think Missouri and Minnesota, Arkansas. They have all weighed in on this topic and ruled that Bristol Myers Squibb should apply to collective actions under the FLSA, which means that if you are based in Delaware and New York, someone can't sue you in, for example, Missouri and represent a nationwide class of individuals. They'd have to go to Delaware or New York to do it. But another court of appeals, the First Circuit Court of Appeals, so think way up in the Northeast, Maine, Connecticut, Massachusetts, they have ruled to the opposite, saying that Bristol Myers Squibb does not apply in the FLSA context. So if you're an employer who is located in Missouri and incorporated in Illinois, if you have employees in Massachusetts, they could file a lawsuit against you and maintain a nationwide class action against you in that jurisdiction. Again, why does this matter? Well, it's because certain courts, certain jury pools, and even certain procedural laws are more favorable in certain jurisdictions than others. Now, when cases do get to the Supreme Court, frequently it's because there is what they call a circuit split, where a group of the federal courts of appeals have reached differing conclusions. We're starting to see that here with the Third, the Sixth, the Seventh, the Eighth on one side, and the First on the other. But in 2023, there was an opportunity for the United States Supreme Court to resolve that circuit split, and it chose not to. And typically it does that when it wants the federal courts of appeals to continue analyzing these issues, maybe creating a larger split, but really more importantly, creating more analysis that could be relevant in a later consideration by the Supreme Court. So they declined it in 2023. I don't know no one knows when or if it will get back up to the Supreme Court. One possible resolution is that there could become a consensus around the courts of appeals where maybe it's just the First Circuit that's an outlier and the rest of the courts decide that Bristol Myers Squibb applies, where the Supreme Court will never have to take it up and it becomes effectively the law of the land. But what they don't want, what the Supreme Court doesn't want, is this mosaic where there are differing laws all over the place. So it's going to take some time to get there, but we will get there. In the meantime, what that means is if you are an employer that has employees in jurisdictions outside of those 5 courts of appeals that have ruled on this, it's unknown what could happen. So for example, if you have employees in Colorado, which is the 10th Circuit, and they decide to file a nationwide collective action against you, it's possible that the courts there, including the 10th Circuit, may decide that that is permissible. And you may need to defend yourself in Colorado, even if that's not your principal place of business or state of incorporation. So you need to be very aware of this because it has a huge impact on the potential liability that you could face as an employer.
Thanks, Joe. Okay, so now Joe just walked us through where you might get sued. Now let's talk about what's going to happen when you get sued. The FLSA litigation is what we're going to focus on. Again, we're talking about Rule 23 class actions under state law, FLSA collective actions under federal law. Our discussion in this section is going to really focus on the FLSA because there's been some changes in what's called the certification process. Class and collective certification is the most critical part, I would say, of these types of cases. And it doesn't even really have much to do with the merits of a claim. So what I mean by that is the certification decision, if it's an overtime case, the certification decision isn't really looking at whether or not you were properly paying overtime. It's looking at whether or not it makes sense for the court to allow the case to proceed as a class or collective action, meaning all of these employees who never sued you and didn't even know that they maybe had a claim or had any interest in it, all of a sudden now are potentially going to receive damages. So what it does is it grows a claim from that single plaintiff that brings their lawsuit into something much larger. If you prevail on that certification question, then the individual plaintiff is the only one who has their claim against you. Other employees could bring their own claims individually, but for that specific case, once certification is declined or denied by the court, it's just the named plaintiff. And as we talked about earlier, individually, these claims are not that expensive for employers to handle. It's when they grow and get a certified class or collective. So in the FLSA context, conditional certification starts at the beginning of a case, and it's what will allow courts to authorize notice to be sent out to employees. That's that situation where all of these workers who are within the collective will get notice of the case, and then they can affirmatively opt in and become part of the collective. In the past, this has been extremely easy to have to get a court to conditionally certify a case. That's because, and we're going to talk about it in a moment here, there was a case from a long time ago called Lusardi that put together a structure and a standard that has made it essentially just a rubber stamp to the point where a lot of the times we just stipulate to conditional certification because it's often not a good use of the client's money to try to fight something that is just oftentimes going to be approved by the court. So that Lusardi approach is what I was talking about. That's the name of the case from years ago that said, look, we've got to figure out a way to certify these cases. We're not going to go under Rule 23, but the FLSA doesn't have anything in the statute that says how you should certify a case. So we're going to do a two-step approach to determine if these plaintiffs, these employees, are similarly situated. Step one is conditional certification. That will happen at the very outset. They apply a lenient standard, and they require only a modest showing for plaintiffs to send notice to all these individuals. So that means plaintiffs basically can have one person, maybe they get one other to put together a very short affidavit that says, yeah, I didn't receive, overtime pay for all the hours I worked. And sometimes that's going to be enough for a court to say, okay, you guys can proceed as a collective action. We'll send out notice. The reason why that's a big deal is because the case has now all of a sudden grown to much larger, and there is a lot more pressure to settle before you could ever get to a time where you could seek to decertify the class, where you could say, look, that lenient showing, that modest showing at the beginning, that lenient standard, once we actually look at a factual record, now that discovery has happened, there really shouldn't be a collective certified here. But that rarely happens because employers want to get out of the case once it's certified. So it's really created a conundrum for employers. And then in 2021, the Fifth Circuit was really the first federal circuit to recognize, hey, something's broken here with this Lusardi approach. These claims are getting filed and we're just allowing them to proceed as collective actions without really much thought into whether that's the right thing to do. So the case is known as Swales, and this is the Swales approach. And in that case, the Fifth Circuit said, look, we're going to make this look a little bit more like Rule 23. We're going to have the plaintiffs have to answer some legal questions. We're going to have them go through discovery early on, and we want to have a full record of evidence before we decide if a collective should be certified and if we should send out notice. This is a huge departure from what Lusardi did. It basically is saying no longer are we just going to allow employers to get hit with collective actions just by one being filed. We are going to make plaintiffs' attorneys have to do a little more work to show that this should actually proceed as a collective action and it's not just an individualized claim. Again, Swales is just limited right now to the Fifth Circuit. That's your, Texas, Mississippi, Louisiana, but it is influential. And we're starting to see other district courts and other circuits start to question Lusardi, and the Fifth Circuit's really the one that kicked it off. Shortly after Lusardi, that's what the Sixth Circuit did. That was the case Clark. The Sixth Circuit said, look, we don't really like Lusardi, but we're not too sure that Swales is the correct approach either. There's been this two-step method for decades. We think we should stick with that. But at the same time, this lenient standard and modest showing it's really not enough. So what we're going to do is we're still going to keep this two-step approach, but we're going to raise that burden. There's now going to be a strong likelihood requirement. Okay, so what does that really mean, right? The Clark court wasn't saying you need to engage in discovery before you file your motion for conditional certification like Swales did. But by putting in this strong likelihood burden, they are essentially requiring plaintiffs to have to engage in some type of discovery, which again is helpful for employers because the more record that's developed, the more likely it is that you might be able to say there is no collective here. They are not similarly situated employees. So even though in Clark we have still a two-step approach, it is more like Swales than it is like Lusardi, I will say, even though on paper it might look like Lusardi. Look, we really think that this is just the beginning. These are just two circuits. We've got the Fifth Circuit, some of those southern states, and then the Sixth Circuit like Ohio and Michigan. They're the ones who've come out, and we would expect other circuits to do the same. The Seventh Circuit has already said that they're going to revisit Lusardi. We expect that decision to come out maybe around the end of the year, a little after. That will be telling because that's a state like Illinois, and we know there's a lot of employers in Chicago. A lot of this litigation gets filed in the Seventh Circuit. A lot of big wage and hour decisions have come out of the Seventh Circuit in the past. So if the Seventh Circuit comes in and says, look, we also think Lusardi is not really the way that we should be doing this now, we would expect to see other circuits follow along with that, or at least really start to take it more seriously and reconsider it. And like Joe was talking about earlier with circuit splits going to the Supreme Court, we would not be surprised if that happens here. This is something that has been around for a long time. Now it's finally being questioned. Supreme Court will probably want some other circuits to weigh in. There's only going to be 3 of them here soon. But once that happens, it is likely going to be an issue that gets brought up to the Supreme Court. I'm going to send it over to Joe, and he's going to talk about rounding.
Thanks, Scott. I think it's important to pause for a moment and apologize. There are people on the West Coast who are reading or hearing this at 7:30 in the morning. Scott's use of the word conundrum is probably unfair at 7:30 in the morning, so we'll revisit that when we review the tape. On the point that Scott was just making there, it's a good time to sort of step back because that was the real case analysis with certification and where you can get sued that we wanted to mention. The upshot of all of this is it's becoming a little less clear as to what the potential liability could be when your wage and hour practices get challenged. Thankfully, it's becoming less clear in a bit of a trend that's positive for employers, but we don't know exactly how that's going to shake out or how long it's going to take to shake out. So this is what it's really highlighting is the importance of making sure that your practices don't violate the law, or at least aren't the types of practices that are easily and more frequently challenged by plaintiffs' attorneys to try to build these really big nationwide class and collective actions with 7, 8, and 9 figures of liability. So the transition here is to talk about one of the areas that gets hit the most frequently, and that's rounding. I'm going to explain what rounding is in a moment, but it's absolutely one of the more common claims raised by plaintiffs in wage and hour litigation, in large part because it's an easy thing to prove, it's an easy thing to certify, it's a challenging thing to implement correctly, and it's something that tends to happen a lot without a lot of real focus by the employers that are actually deploying it. More troubling than that, it's becoming less defensible in courts all around the country. Scott talked a little bit about the differences between state laws and state courts and federal laws and federal courts, and we are seeing that mosaic evolve as to what is permissible where when it comes to rounding. And we've even seen some of the most employer-friendly circuit courts, federal circuit courts, cast doubt on the viability and propriety of rounding. And I'll talk more about that in a moment. But let me explain a little bit what rounding is to those of you who may not be familiar. And by the way, I would hazard a guess that more than half of the employers listening to this presentation today probably have some sort of a rounding practice in place. But the general concept is, let's say an employee clocks in at 8:03 a.m., and that's for a shift that starts at 8. Their time, the system will round their time back to 8 a.m. So in that instance, the employee is getting paid 3 minutes of time that they didn't work. Let's look at the end of the shift. They're supposed to work till 5 p.m. They clock out at 4:58. The system rounds this time to 5 p.m. Again, in the employee's benefit, to the employee's benefit. They're getting some time that they didn't actually work. Now, the reality is, though, the practical reality is that's not usually how it goes down. Usually what it is, an employee wants to be on time for their shift. It starts at 8 a.m., and so they're going to clock in at 7:57. And they're going to work all the way to the end of their shift, and they're going to work till 5 p.m. So that 7:57 gets rounded up to 8, and those 3 minutes get lost. And the employee works till, let's say, 5:03. Those 3 minutes get lost because that gets rounded back to 5 o'clock. So now there are 6 minutes, arguably, that the employee was on the clock, but that time gets rounded away. And most rounding practices that exist round in 5, 10, 15, even 6-minute increments, rounding to the nearest increment. The key is rounding itself is legal under the FLSA. It is blessed under the regulations, as long as the rounding practice averages out over time, and that's the critical phrase, over time, and doesn't favor the employer in a consistent and regular way. The premise there is employees need to get paid for all hours worked, and if rounding allows an employer to accomplish that in a way that's more administratively feasible, then great, but they've still got to get paid for all hours worked. You can't underpay the employees. And so, let me go back actually for a second before we go to this slide, because I wanted to read something off. I mentioned before that at least one of the most employer-friendly federal courts recently has called into question whether or not rounding is appropriate. I want to read to you exactly what they say. In this case, this is the 8th Circuit, and they struck down a rounding practice, or at least called into question a rounding practice that involves a large hospital system in this region of the country. And the court said here, with automated electronic timing and accounting, so this is a reference to what we were talking about before, evolving technologies, systematic or routine underpayment over a period of time is easy to verify because the system records the exact time that an employee clocks in or out. There is no administrative hassle. This is not like the old days of punch cards and hand arithmetic. So it really calls into question, why are we doing it? If you have a rounding practice, why? It can't be because it's hard to calculate these things. As the court said, the technology has changed that. And it better not be because you want to save money, because that's explicitly impermissible. You can't underpay your employees. So the question is, why do we have it? You can have it, but while you're thinking about that, make sure that it's fair, that it balances out well. You need to check those practices regularly to make sure that you are complying. Make sure that you're explaining these policies to your employees. And then if there are problems, make sure to adjust. That's our highlight today of our wage and hour practices and the recent litigation that impacts the potential liability for employers across the country. I'm going to send it back to AJ to continue on with the seminar.
All right. Thank you both, Joe and Scott, and welcome back to my smaller studio next to their fancy big one where they get to sit down. We're going to have, as I mentioned, a series of presentations today. And so this is our first short break in between presentations. After this break and the next presentation, we'll have a slightly longer break. So if you need to step away and you plan to join us all day, that would be an opportunity to do so. For those of you who are concerned, don't worry, we will continue to provide content even during the longer breaks to keep you entertained and engaged. So to that end, let's find out a little bit more about our next speakers. So the next topic we're going to hear about is the NLRB updates. And to bring us that topic, we have two fantastic labor lawyers, Megan McManus and Marianne Zach. And both of them have a rich backstory on how they came to our firm, the experiences that they brought with them, and where they currently practice law. And it's that last thing we're going to focus on as we dig in. But before we get to that, a few words about Megan. So Megan is a theater major, and theater in that sense has an RE at the end. So you know it's a serious study of the theater, RE, arts. But then she became a lawyer. I hear my mom's voice in my head saying, if you get a theater degree, you're destined to be a lawyer. She certainly said it when I got an English degree. But Megan did other things. She also became a member of an actors union, and she even worked in human resources for an actors union before switching to the other side and now representing employers and advising on labor issues and before the labor board. But her story gets most interesting when you find out that her labor practice began in beautiful New York City. And then when joining our firm, she was able to take advantage of the Link, which is our virtual office that allows attorneys for Husch Blackwell to not be restricted to where we have a physical office, but rather to work wherever we find ourselves. I'm a member of the Link. It's allowed me to follow my wife's career and move to various places in the Midwest, currently Michigan. And Megan used the Link to move from New York City to, I think, a fairly comparable burb in southern Arkansas called El Dorado, where she and her family have purchased and keep up an old house and spend their time standing on ladders, doing work on their fixer-upper home while also being visited occasionally by neighborhood ponies, walking down the street to the local high school football games, the sorts of things you do when you live in southern Arkansas, and probably a pretty similar facsimile of the life that they experience in New York City. But also joining us in that presentation I mentioned is Marianne Zach, and she's another member of the Link and another attorney who, because of the Link, was able to leave behind New York City and move to a different clime. She actually took her family to Charleston, South Carolina, well, near Charleston, South Carolina, where she began or embraced the palmetto state. That's a palmetto, at least Google says it's a palmetto, and that's an AI image of one. And an interesting experience for Marianne is that after moving to South Carolina, she had to take another bar exam. So for those of you non-lawyers out there, or for those of you lawyers in states like Wisconsin that let you practice despite not taking the bar exam is not the most fun thing to do on the planet. It's sort of a rite of passage for young law school graduates. And it's something that once it's done, you never want to do it again. But Marianne was so committed to her practice and to the firm and to being able to give her family the experience of living in South Carolina that she studied for and took the bar many years out of law school, having to learn a lot of topics that you learn for the bar and then never think about again. So if any of you have any questions you'd like to share today about things like trust and estates or negotiable instruments, that's like a check, or if you want to ask her about constitutional questions, she's your person and she'll jump into that and lean on that bar studying that she recently did. But regardless, we are excited to have both Marianne and Megan as part of our labor team, no matter where they are. And today they're in St. Louis, and I'm going to send it to them in the studio to talk to you about NLRB updates.
Thank you, AJ, for that wonderful introduction. We're so glad that you joined us today for 2024 NLRB updates and developments. I'm Megan, here with my esteemed colleague, Marianne. I've had the very good fortune of working with Marianne for a number of years. And most recently, we have joined the Link, and yeah, very happy to be here at Husch Blackwell. And so the NLRB is very busy for the last few years, and 2024 is no different. So we should dive right in. So of course we have the National Labor Relations Act that is prosecuted by a person called the General Counsel, and then the cases that are brought, those cases are decided by the National Labor Relations Board, and then that National Labor Relations Board also makes rules to complement the act. And so much of all that we're talking about today is depends on who is in these positions. So we have Jennifer Abruzzo, appointed in July 2021 for a 4-year term, and that term is set to expire in July of 2025. Unclear if she will be reappointed if Harris is president. And then, of course, if Trump is elected, he would, as has happened in the past, could terminate her immediately and appoint someone else. And that's significant because the cases that the NLRB has before it to decide is dependent upon what the General Counsel decides to prosecute. And so we start out, so much of this discussion is about the way the politics shape the cases, the way the politics shape all of this. So then we have the board. That's 4 members and a chair, 2 Democrat seats, 2 Republican seats, and then the chair, who can be Republican or Democrat. And we have Dave Prouty and Gwen Wilcox, who are Democrats. Their seats are set to expire a couple years in the future. An open Republican seat that has been vacant since 2022, and a chair of the board whose seat is set to expire at the end of this year. So this is just really interesting background and context, I think, before we get into the substance of what we're talking about, because obviously we are very much in the middle of election season, and we will know in November who the next president will be. And so currently the agreement is that under a Democratic president, that the current chair will be renominated, and a Republican by the name of Joshua Deidelberg would be nominated for the Republican seat, and that seat would be filled, and we would have still the Democrat majority on the board. Now, of course, a Trump presidency, all of this would be completely upended, and it's very unclear who would be in these positions, but suffice it to say, there would be certainly a Republican in the chair seat, and the board would be majority Republican, and the General Counsel would be a Republican, and that would be the person who would be bringing the cases before the board. So speaking of presidential elections, and we're certainly, politics is all top of mind for everyone, employers need to be aware of how the act applies to employee activism and political speech at work. So, Marianne, would you please tell employers what they should be aware of when it comes to employees engaging in political speech at work?
Of course. Thank you, Megan. Yes, this is top of mind, very timely topic, and maybe many of you folks out there are dealing with this already in your workplace. Before we dive into some recent cases concerning employee activism, political speech in the workplace, let's start at what is really the cornerstone of the National Labor Relations Act. You may have heard this term, protected concerted activity. What does that actually mean? So at its core, it's really employees banding together, gathering together to improve their lot as employees, to improve their terms and conditions of employment, their wages, their hours, safety in the workplace, being heard in the workforce. And concerted meaning 2 or more employees together, although a single employee could spearhead group action. So although they're acting individually at that time, if it's in furtherance of the group activity, it would certainly be considered concerted. The purpose must be for mutual aid or protection. So it cannot be in what we call an individual gripe or grievance. It must be for a group action or activity that affects employees as a whole. The Act protects it, so you cannot retaliate or discipline or have any adverse action against an employee or employees who, for example, discuss their salaries together, who bring a group complaint to you concerning maybe safety conditions in the workplace, or at times, we see that where this is going, political speech and employee activism, although we don't automatically think that it can impact the workplace, it can be protected. So we're going to discuss these 2 cases that are basically opposite sides of the same coin. So Megan, if you could tell us about the Home Depot case.
Happy to, thank you. So these 2 cases, Home Depot, Parkside Cafe, Home Depot decided at the beginning of this year, and then Parkside just last month, illustrate how political speech could be protected at work. And so in the Home Depot case, we had an employee who on their orange apron wrote BLM for Black Lives Matter, and the employer told the employee that they had to remove those initials from their apron as a requirement to continuing their employment. And the employee refused. The employee was not terminated, but they considered that a condition that they couldn't accept and decided to resign. And it was determined that that was a constructive discharge. Now, along with writing the initials on the apron, the employee, there were issues with a manager treating African-American shoppers differently than any other shoppers in the store, and employees had gone to management and complained about it. Now, that was considered the protected activity, some of the protected activity that had happened in the store, and the employees writing the initials on the apron was tied to that concerted activity of the other employees and considered a logical outgrowth of that protected concerted activity of the employees banding together and going to management and saying, hey, we have these concerns about the way the manager is treating shoppers. And there wasn't really a question of whether that was protected concerted activity. The question was this employee's lone activity of writing the initials on the apron, which he was the only one that did that, whether that was protected, and as a result, his constructive discharge violated the act. So the board agreed that writing the initials on the apron was protected concerted activity. The dissent explains the reason why they disagree with this and why this case was a complete departure from NLRB precedent, because logical outgrowth tends to necessarily mean that one happens after the other. And in this case, the employee writing the initials on the apron came before the employees engaged in the protected activity. So this is something employers should absolutely be aware of in considering whether or not an employee's lone activity might be logical outgrowth. Home Depot tells us just because it didn't happen after the protected concerted activity of the employees banding together doesn't necessarily mean it's not tied to the protected activity of the group.
Certainly, but it's not all bad news for employers. We did have a good case that came out, like Megan said, last month called Parkside Cafe. And this shook out more, what we think more logically in terms of, how to apply this in your workplace. So in this case, briefly, it was a bar restaurant, and their servers, and it was also during the height of the COVID-19 pandemic. So restaurants were closing early, businesses were on lockdown, and it occurred around the same time of Black Lives Matter protests and protests concerning police treatment of African Americans and the George Floyd killing. So here, the bartenders and servers attended protests, some together. Sometimes there were 2 or 3 servers together attending these protests. Other times they were just attending them by themselves on their own time outside the workplace. And managers, 2 managers took issue and started criticizing them participating in those protests because, there was frustration. Oh, our business is closed, or, oh, you employee are complaining that you're worried about exposure in the workplace, but here you are attending a protest with, thousands of people. There was no retaliatory action taken or no, threats of reprisals for attendance, just some, tension between management and the employees. So at the end of the day, these employees similarly felt like they had to resign. And then they brought a charge saying they were constructively discharged as a result of their engagement in that protest activity. And the board looked at it and said, was there an actual connection between that activism and the workplace? And there is a case out there, you see it on your slide, called Eastex, where employees can engage in activities that support other employees. So not necessarily employees in their own workforce, but other, employees of employers outside their workspace. And here, the board said the protests did not address race discrimination in that restaurant bar, in that workplace, or workplaces in general. So there was really no nexus between the activist conduct and workplace issues, either at that restaurant or just race discrimination at work in general. So the board said there was no connection, and as a result, the employees were not considered to be constructively discharged in violation of the act. So, good news for employers. It kind of clarified things where there has to be that connection or nexus versus just outside employee activism that really has no logical outgrowth from that protest or activist activity.
Right. So I guess logical outgrowth doesn't necessarily have to be, the individual activity happening after the group activity, but there has to be
a connection there.
Some connection.
100%.
Just a lesson from these 2 cases.
Exactly.
Perfect. Thank you.
Thank you.
So the board also addresses whether or not an employee's speech loses the protection because it becomes, it's very, it's threatening, it's harassing, it's so, it becomes misconduct, right? There's lots, the extensive body of NLRB case law that addresses this issue. And prior to this case, Lyon Elastomers, the standard for evaluating whether or not an employee's speech, protected speech, lost the protection of the act was the standard, the same discrimination standard that is used in any sort of case when determining whether or not an employee was terminated because of their protected activity. The case we all know and love, Right Line. So the general counsel has the burden of proving whether or not the employee, of the prima facie case that the employee was terminated for their protected activity, and then the employer can rebut that prima facie case with evidence that they still would have terminated them anyway. And in this case, it would be because the employee violated a harassment policy, for example, because what they said was so harassing, so very, violated the sexual harassment policy. It was a very racist comment, for example. So Lyon Elastomers comes along, 2 versions of this case, actually, and this case changed the standard to setting specific. So it's no longer the case that employers can just evaluate whether or not an employee's speech might have lost the protection of the act, regardless of the setting. You have to consider whether that speech happened inside the workplace, whether it happened online, social media, or whether it happened on the picket line. And those are varying degrees of the kind of, frankly, misconduct that an employer must tolerate. Less in the workplace, a little more on the online, and even a little more on the picket line. I've yet to see a good explanation from the board, certainly currently, why on a picket line in 2024, why we need to tolerate, sexist comments, racist comments, but here we are. Now, technically, this case has been reversed and remanded by the Fifth Circuit. They actually reversed and remanded and scolded the board in this case because the board sort of used an interesting maneuver while the board majority switched from Republican to Democrat. Going back to our earlier slide of why the politics of all of this really matters so much. So technically, line elastomers was reversed by the Fifth Circuit, but that's just in the Fifth Circuit. And regardless, it's still the case that this is the way the board is going to review these kind of cases. The practical effect is it's harder to enforce your zero tolerance harassment policies if there's also protected concerted activity involved as well. But it doesn't mean that these policies should not be enforced. They should be certainly enforced very evenly and consistently, but be sure to not question about Section 7 activity, and remember Johnny Poultry statements. And if we don't know what those are, call your friendly labor lawyer, and we'll be happy to explain what those mean. And then wrapping up this section of speech, employers, can they speak? Well, sort of. It is. We still have the First Amendment. Employers still can speak. The board takes a position that employers' speech is inherently coercive, especially when they force employees to listen to their speech. We're talking about these mandatory meetings, captive audience meetings, particularly during an organizing campaign. We're seeing unions they've initiated throughout state legislatures bans on these kinds of speeches. And so we have almost 10 states now that have banned these kinds of captive audience speeches. So employers in these states should be very careful to review handbooks and policies and clarify whether such meetings are mandatory, and certainly not treat employees any differently for attending these meetings. Consider whether or not it's worth the risk of having the meetings or not, evaluate what effectiveness they might have. And speaking of handbooks and policies, huge topic for the NLRB. So I will turn it over to Marianne to discuss our favorite case.
Stericycle. Yes, thank you, Megan. So handbooks, policies, you may not think it's the most important or riveting aspect of your business, but it is very important in this post-Stericycle world that we live in, where the National Labor Relations Board has essentially become the handbook police. We're not going to go into too much detail as to Stericycle and the case and the holding, but the bottom line is what came out of Stericycle was that now rules or workplace policies, they're presumed to be unlawful. They're presumed to be coercive. If there's a reasonable tendency to chill employees from exercising, organizing conduct, engaging in protected activity, or if it otherwise has a coercive meaning. So now it's not would this rule, limit an employee from engaging in PCA, but could it? We're dealing in the hypothetical. And the board takes the position that the rule has to be looked at through the lens of an economically dependent employee. And aren't we all economically dependent when we are employees? Mm-hmm. So, the board really is, employers have to really wordsmith now and be very intentional when they're drafting, and we're going to get into drafting tips in a little bit, but it really has to be that this rule that you drafted is the most narrowly tailored rule, and you're going to have to explain how it is or why it could not be more narrowly tailored. So, the reason why this is so important is there's this case out there called Cemex, which again we'll be speaking about in a bit, but a overbroad or vague policy that can reasonably chill an employee from engaging in PCA or organizing activity is an automatic violation of the act. So even if you don't implement it in a discriminatory or violative way, if it just exists, and let's say it's a policy you haven't looked at in 10 years because it came from, the handbook way back when, it does not matter. Automatic violation, and that could really get you into some sticky situations when it comes to the post-Cemex world that we're living in with union organizing. And if an employee comes to you and says, we have a majority, recognize this union, and if there's now a pending ULP, unfair labor practice charge that is out there, that union can get in a lot easier and could essentially force your hand. So just really important stuff. There's at least one region out there, 28, that has issued a bargaining order over an unlawful handbook rule. So we truly, just want to emphasize handbooks are important, rules are important, and to kind of review what you have out there. And if you haven't done your annual review yet, certainly contact your counsel who could really walk you through that. So I think we have the next slide, Megan. Perfect. So these two cases are relatively recent. Now, the problem with Stericycle is, the board handed down this edict about handbook rules, but it leaves employers a bit in the dark because now, okay, well, what's lawful and what's not? How do we draft this? It's, now everything's a shade of gray. And unfortunately, because the Stericycle case was only decided a year ago, the board hasn't really acted since then to come out with clear directives concerning these types of rules. So what we've been looking at is some administrative law judge decisions to kind of help employers guide them through and say, okay, in this case, this is how the ALJ, looked at this language. So here on your slide, there's two recent ALJ decisions, one pro residential services, and this is concerned an off-duty conduct policy. You could see the language of the policy on your screen. But if you look at the last sentence, it says illegal or immoral off-duty conduct on the part of an employee that adversely affects the company's legitimate business interests or the employee's ability to perform his or her job will not be tolerated. And we highlighted the term immoral. And the ALJ found that the rule's prohibition on immoral conduct was overly broad. It was not defined. It was not narrowly tailored. So we can think of a universe where an employer says, oh, you employee, supporting a union, I think that's immoral, in the employer's point of view. And there is a world of possibility where immoral off-duty conduct can cover protected concerted activity. So the ALJ there found that terminology was overbroad and it could restrict Section 7 activity. The second case, ExxonMobil, it was a confidentiality standards of business conduct. And if you look at the last sentence, it says examples of confidential information include non-public information about the corporation's plans, earnings, finances, business forecasts, discoveries, competitive bids, and personnel. So plans and personnel. Now, you look at this and you think, oh, it's specific enough. This looks like it's narrowly tailored. You're giving examples, which is, stuff that Megan and I advise clients. When you have policies, make them as specific, give examples, so your employees know exactly what you're talking about. But corporations' plans, we all know that probably meant the corporation's confidential business plans, next step in their operations. However, an economically dependent employee could look at plans, could look at personnel, and they could interpret those ambiguous terms to mean, oh, plans, benefit plans, personnel, employee information, wages, all of that which is covered under Section 7. So those are just two examples of how, seemingly innocuous language that is not coercive could be deemed to be so by the board. So Megan, please tell us about, what are employers to do? How are they to draft these policies in a lawful way?
Thank you, Marianne. I think you did a really good job of covering the drafting tips, narrow as much as possible, defining terms as much as possible, quoting language from cases that have, blessed particular policies is certainly something that we do a lot of in advising and counseling clients. But so certainly that's the advice in general that we give. Now, I want to take a moment to talk about something that is a little known. I don't know that it's little known. I don't hear a lot of discussion about it, but I think it's a very important topic related to handbooks. It certainly touches other areas, but it's the concept of retroactivity. It's when the board decides a case and it applies it back to all the other cases that are pending before it. So, as we apply it to handbooks, this could be, you've drafted a handbook policy and copied a case that the board decided and blessed a policy that, in 2020, and you know that this policy the board said was okay, so you copy it, and then the board later decides that that policy was illegal. This happens all the time. So in that case where they now decide that your policy is now unlawful, they can retroactively apply that case to the cases pending and find your policy unlawful, that when you made the policy, it was lawful. Now, whenever the cases decide whether or not to apply retroactivity, they talk about case by case and whether it would be a manifest injustice, and talk about to what extent the employer relied on the law as it was when they drafted the policy. So I think an important takeaway for employers when drafting these policies is to document when you revise the policy and what law you were relying on when you drafted the policy, to at least have the chance of a defense of having retroactivity not applied to you, to make the case that it would be a manifest injustice to have the case applied to you after the fact that you couldn't possibly have known would exist. So with that, we're going to talk about organizing and collective bargaining. Obviously, huge topic, so much activity happening with NLRB case law, and of course, in the, in just the world at large, in the U.S. So Marianne, talk us through what's happening in trends and organizing and bargaining.
Yeah, so, the labor landscape has been changing. I mean, I've been practicing for 10 years, and in that short time, it's, the pendulum swings back and forth for sure, especially depending on, the presidency and who's in office at the time. In terms of organizing and bargaining trends, it's really been interesting. I think a lot of us, when we think of unions and traditional labor, we think construction, we think manufacturing, we think those jobs that are just the stereotypical union labor jobs. And that has really not been the case lately. Organizing has taken a totally different turn, and really new and non-traditional industries are starting to get organized. For example, medical residents in academic medical centers, huge organizing push by the Committee of Interns and Residents, banking, baristas and restaurant workers. Obviously, Starbucks has been in the news constantly. Even physicians, post-residency physicians, we're seeing an uptick in organizing. So truly, these are industries that aren't typical when you think of unions and traditional labor, and the reasons why they're organizing, and what employees are looking for when they do are different than the reasons 20, 25 years ago. So now we're seeing a new generation of workers who aren't necessarily looking for the highest pay or increasing their hourly wage, which of course I don't think anyone would say no to. But really the primary issues are work-life balance, flexible time off, non-economic issues, having a seat at the table, really being able to drive change in the workforce. So it's really different than the past and what we've previously experienced. Obviously, health and safety continue to be huge issues. It really came to a head during COVID, continues to be so, especially in the medical field. These are informed and educated workers, and they are activists. They really are pushing the needle in activism and even taking strike votes before bargaining begins, which is very rare. So now these employees are ready and willing to take the risk of a strike to ensure that they get what they want at the table. I briefly mentioned Starbucks. You could just see the proliferation of unions in that organization. 3 years ago, 0 bargaining units. Now, September 4th, 2024, 476 units are certified basically in every state. Over 2,500 petitions for elections filed during fiscal year 2023. We're only halfway through 2024, but there was a recent survey that was issued a few days ago, and basically there's been a 35% increase in election petitions filed from the start of 2024 till now. So I'm sure that number is really going to be increasing by the time 2024 ends. So obviously the surge in representation activity, there's also been a large increase in unfair labor practice charges against employers filed by unions. Finally, a huge driver, at least in my career, I never really saw employers file what's called RM petitions, petitions for elections, right? Usually that's left to the union or employees to drive that. But post-CEMEX, and Megan's going to be explaining this, there's been a significant uptick in those employer-filed petitions for reasons that Megan will be explaining.
Thank you. Yes, so CEMEX happened last year, but it's in 2024 that we are seeing the impact and the effect, and now bargaining orders being issued under this case, the real activity and the results of CEMEX. So quick recap of what happened in this case. So complete unprecedented case that decided a completely new way that an employer could become obligated to bargain with a union. In this case, under the CEMEX framework now, if employees present to the employer that a majority of employees in a appropriate unit present that a majority support being represented by a union, and in no particular form, just could be cards, could be petition, electronic, paper, send in an email. There's no, it could be various forms, something that your managers and supervisors should absolutely be educated on. But basically that starts a clock ticking, a 2-week time clock, that the employer must do something. They have to file their own petition to request an election to determine whether or not the employees truly do want the union to represent them. Because if the employer does not file that petition, then the union will be automatically the collective bargaining representative of that group of employees, and the employer will be obligated to bargain with that union over any term or condition of employment with respect to those employees. So that's a major shift. And the other critical piece, even if the employer files that petition and they successfully make the deadline, if before, during, after that process, that election time, critical period is a sort of term of art that's used, the employer commits an unfair labor practice. You heard Marianne talk about a handbook rule violation. It could be just not in theory, it could be a dormant handbook rule laying there. An unfair labor practice could be what actually sets aside the result of any election, and still the employer is obligated to bargain with that union. So Cemex is a huge case, and we're seeing in two recent cases, we have two bargaining orders and two different postures. One in Massachusetts, where the bargaining order was issued in the form of a 10J injunction. That's preliminary relief under the National Labor Relations Act. So in that case, there was an election, but there were, the region determined that there were unfair labor practices. And so even while this case is being litigated and all of that's being determined, they successfully got a court to say that the employer still must meet with the union, certainly keep status quo of the terms and conditions of employment, and sort of act like the union is the representative while the case is being litigated. Red Rock Casino, again, an election was set aside as a result of unfair labor practices found. So what is clear is employer conduct is under intense scrutiny. So at any time, but particularly if your employees are engaged in union activity, it is critical that employees be very careful and aware of what activity is protected, and be very mindful of what their response is. The case, of course, is pending in the Ninth Circuit. Mark your calendars for oral argument in October, which may happen. The case may be decided on the papers. We don't know. Will this case survive now that the board does not have Chevron deference? That remains unclear. We know they at least have Skidmore deference, which requires, which at least looks to consistency with earlier and later pronouncements. So because this case was such a radical departure from anything the board has ever done, maybe, I've heard a lot of commentary about, that it seems it could be that the case is overturned, but not yet, and it's certainly the law now. So stay tuned. The other topic we'd like to share with you today is settlements and remedies. So how these cases get resolved and the results of cases. So Marianne, can you talk about consent orders, big case that came out, Metro Health?
Thank you. And like Megan mentioned before, the General Counsel, Jennifer Abruzzo, is really, pushing her policies and her agenda in cherry picking these cases and deciding which cases go forward and the results that she is seeking through these cases. So this came out, less than a month ago. And as you see by our title, rest in peace, consent orders. Essentially, for over 50 years, consent orders have been the status quo at the National Labor Relations Board. What are consent orders? Briefly, they are slightly different than settlement agreements. In a settlement agreement, two parties, the respondent, typically the employer, and the charging party or the general counsel both agree to terms of a settlement agreement to settle an unfair labor practice charge. For a consent order, typically the respondent employer presents, terms of a settlement to an administrative law judge, to the neutral third party, who then says, okay, you know what, this furthers the purpose of the act. It creates a labor peace. It conserves resources. Let me, stamp this and move on. And the parties, agree to abide by the consent order. The consent order can be done without general counsel approval or without the charging party approval. So slightly different than a settlement agreement. In this case, the underlying unfair labor practice charge was pretty simple. It was the employer just refused to provide the union information pursuant to an information request, which is required under the act. And the employer presented a consent order to the administrative law judge, which basically had every single term of a proposed settlement agreement that the general counsel already agreed to. Only two different terms, a non-admissions clause and not providing notice of a violation of the act via text message to employees. So, this was a solution everyone was on board with. Unfortunately, for the employer and the union in this case, the general counsel said, you know what? Consent orders are not allowed. They were really never permitted under the rules and regulations of the board. Let's forget 50 years of precedent in case law and accepting these consent orders. They don't further the purpose of the act. And they interfere with the GC's prosecutorial authority. As a result, the GC has used this case to push its agenda to get rid of consent orders. But now the union that filed the ULP that wanted this information years ago is tied up in litigation. So it's been like 4 years. The union doesn't have the information, which apparently furthers the purposes of the act. But it's kind of laughable that the GC is pushing this agenda, and now the union is stuck there still without the information it's seeking. So Megan, over to you.
Which was totally the criticism, right, of the dissent. It was
correct.
Now the abolition of consent orders would only allow the general counsel just to take cases before the board for the sole reason of pursuing a political agenda. And it seems to be kind of what happened in this case, because if resolving the unfair labor practice, which was for the employer to give over the information to the union, why delay for years resolving that case just because the terms at issue were not texting a notice to employees and a non-admissions clause? That's all. So yeah, the case really highlights our point about the politics at play here. So consent orders. Turning to remedies. So of course we know Thrive from last year, well, from a couple of years ago, but that was the huge case that changed the calculation for remedies for unfair labor practices. The standard remedy that we've known forever, make whole, which consisted of back pay with interest, a couple of other items, but the Thrive case defined that make whole remedy as all the direct or foreseeable pecuniary harms, including things like the cost of repairing someone's credit, the cost of renting a car, if you lost your company vehicle as a result of your discharge, things like that. So the case was appealed to the Fifth Circuit, and the Fifth Circuit reversed and remanded it on the merits only, and didn't opine on whether or not the board could depart from its standard, its precedent on determining what make whole remedies meant. But it did certainly criticize the way the board arrived at direct or foreseeable pecuniary harm, and it called them consequential damages, which I think is significant in light of Loper Bright and the other cases that have cut back on the deference that cases are getting. So I think that might be some significance there. And then looking ahead to bargaining remedies.
Yep. So this will be, I think, the last topic we touch on
Yep.
Before we wrap up. But bargaining remedies, the current case concerning a charge for bad faith bargaining, if there's a violation, basically says the remedy is just order the parties back to the table. So almost like no harm, no foul. However, and that means no make whole remedies, no monetary relief when it comes to a bad faith bargaining charge. The general counsel, Abruzzo, am I right, is looking to establish make whole remedies for the lost opportunity to bargain. And it's so ambiguous as to what could that mean for employers, because what's a make whole remedy for the failure to bargain a potential hypothetical contract? You don't really know, right? Proposed, looking at comparator data of other collective bargaining agreements to determine, what that dollar amount can be. But we know it's on Abruzzo's radar. She's even given an interview recently where she said specifically, you need to hit employers in their pockets for engaging in bad faith bargaining. And there's numerous cases where the general counsel has filed motions specifically looking for these make whole remedies for failure to bargain. So something we have to have on our radar. We do hope it goes both ways, right? If a union fails to bargain in good faith, we hope the general counsel would apply this policy to them as well. That remains to be seen. But also just want to point out that recently in Region 6, there was a large settlement agreement where an employer did agree to pay almost $300,000 as a result of that bad faith bargaining.
Yeah. And with the last 10 seconds, 5 seconds we have, we'll just mention the rulemaking that the board engaged in this year, fair choice, employee voice, made changes to a blocking charge rule and the voluntary recognition bar, and made some rules with respect to the construction industry. All of that is in your materials. And we thank you so much for joining us today.
Thank you.
All right. Thank you, Marianne and Megan, and welcome back to this short break. And apologies, I think I gave the wrong information last time. We have one more short break before our next presentation, and then we will have our longer break. So hopefully you have the stamina to make it through one more presentation. And if not, certainly feel free to step away and come back now during this short break. But we're going to introduce our next speaker, and we are going to move to a topic. One moment, let me make sure I click the right thing here. We're going to move to a topic about affirmative action plans, OFCCP audits, prevailing wages, and other federal contracts compliance issues. And you're going to hear from our colleague, Michael Schreier, who joins us today from St. Louis, but is normally working for us, as many government contracting attorneys do, from Washington, D.C. I do like the fact that when we put Michael Schreier, D.C. up there, it makes it seem like he's a chiropractor and could give one of your employees one of those questionable notes that takes them off of work for long stretches of time. And then we have to work through the interactive process with them. But he's not, he's a lawyer, and he identifies himself as, quote, the missing link. So you're expecting an AI image, for those of you who've been with us so far, of Michael Schreier as some sort of Yeti or Bigfoot. But that's not true. You're not going to see that. He calls himself the missing link because he is a government contracting lawyer who specializes in labor and employment. So he is somebody who can advise employers very specifically on the intersection of those two issues. And it's something that he regularly does, and it's obviously going to be what he helps you all with today. And it's apropos that he calls himself the missing link, but is not going to be demonstrated as Bigfoot, because when I was exploring interesting things that I could share with you about Michael Schreier, the human being, not just the lawyer, there was almost nothing out there. I think it's probably a reflection of the fact that he works with the government, that he does an excellent job of scrubbing anything that not only would be incriminating, but also could even be construed as interesting about him from the internet. So it is a dearth of fun facts. So I went directly to the source. I said, you know, Mr. Schreier, I assume that there's something interesting about you. You're certainly an interesting and engaging person. What can you tell me? And his response, truly, was to tell me that he wears a size 10 shoe. And that's it. That's what we've got. So we have Michael Schreier, the shoe filler, coming to talk to you soon about government contracting. And the size 10 of it all makes his interesting fact particularly uninteresting, because the current average shoe size for men in the United States is 10 and a half, which puts Michael just slightly shy of average. And it used to be about 30 years ago, 9 and a half. I had to do some research to pump up this interesting fact he gave me. It used to be 9 and a half about 30 years ago. So while Michael Schreier was busy wearing his 10 and a half shoes, or size 10 shoes, he went from being slightly above average to watching the rest of the world pass him up and leave him in its dust. And now he is, in fact, a bit small-footed. But he's sure-footed when it comes to the topic of government contracting, and that's what we're going to send it to the studio and to Mr. Schreier to talk to you about.
Thank you, AJ, for that great introduction. Welcome, everybody, to the wonderful world of federal government contracting. So the federal government is probably the largest single purchaser of goods and services in the entire country. Somewhere between a quarter to a third of the U.S. economy touches the federal government's procurement. And we're talking things from battleships to paper clips, from prison construction to mowing the lawn at the U.S. State Department. Wide range of services are always covered here. And so what you're going to hear throughout the day here is labor employment laws that apply to anybody who's doing business in the United States. What I'm going to talk about is the rules and the requirements for contractors that choose to do business with the federal government. Because basically, if you want the federal government's money, you got to comply with all the strings that the federal government attaches. So this is what we're going to talk about a little bit today. First off, we're going to talk about various contract clauses. Like I said, government contracting and the requirements we're going to talk about today are all driven by contract clauses, not by statutes, not by regulations, but by clauses that are put in your prime contract with the federal government, or as a subcontractor, that the clauses get flowed down from the prime contractor. And so today we're going to talk about specifically some of the basic labor employment issues that arise from federal contracting, so, such as OSCCP, affirmative action plans, and compliance requirements. And then also we're going to talk a little bit about prevailing wages for construction, Davis-Bacon Act and prevailing wages, and talk about in the construction context, but there's a similar statute called the Service Contract Act that applies to service contracts. So some of the principles that we're going to talk about today in the construction world also apply to the service world. But what we're not going to talk about, and I just want to put this slide up there so you can take a look, there are a lot of contractual requirements that apply to federal contractors. This is just a short sampling. And you'll notice here, after each one, there's a listing of FAR with a citation number. And this is in your materials, so you go back and dip this in water and it'll turn into a full-fledged presentation. But FAR stands for Federal Acquisition Regulation. And so these are all the contract clauses that the government puts into the prime contract, and that the federal contractor then has to flow down to all tiers of subcontractors all the way down the supply chain. So as you see, there's quite a bit of diversity here as to topics that touch and deal with labor employment issues, but we're just going to talk about 2 or 3 here today. So before we get into that, I want to put you all in the proper frame of mind to receive the information, because there's a big difference between what you're going to hear from all the other presenters today versus my world in government contracting. Because in the commercial world, if there's a labor and employment law violation, typically the plaintiff's bar will step up and file a private cause of action in the federal or state courts, and either a single plaintiff case or a class action. And in situations like the Fair Labor Standards Act or Title VII claims, the plaintiffs can be looking for back wages and your prevailing party attorney's fees and other things. And as you all know, the resolution of those cases, from your perspective as employers, is typically driven by monetary considerations. How much is it going to cost to defend the case versus how much do we actually have to pay out at the end of the day? That's all nice, but in my world, in the government contracts world, it's very different because there are no private causes of action. Any cases that involve breaches of these contract clauses are prosecuted typically by the U.S. Department of Labor. And Department of Labor has the sole authority to investigate and prosecute violations of these contract clauses. Sometimes they respond to complaints. Sometimes they just do random investigations. There's a big database of outstanding federal contracts. They go, okay, we want to do this one this year. And they'll just pick one at random. So you can never be entirely sure when or why you're going to be investigated by the U.S. Department of Labor. And disputes over alleged violations are not litigated in the courts. They're litigated before the Department of Labor's administrative law judges, sort of the, I'll say it, sort of the kangaroo court of the Department of Labor. And so you start off there, and eventually you go through enough administrative processes, you can get to a court, but it takes a long time and a lot of money to get there. So unfortunately, for all this contract compliance stuff, the Department of Labor does not have the same litigation motivations as private litigants do. The Department of Labor is not interested necessarily in the dollar amounts. They want to make sure that contractors rigidly comply with the contractual requirements, and they have a mission. And unfortunately, the Department of Labor, relatively speaking, has unlimited funds to enforcement authority. There we go. All right. So another aspect of my world in government contracting is that all these contract clauses have flow down requirements. Flow down meaning, if you get it in your prime contract from the federal government, or you get it from your customer, they have these clauses in there, then you usually have to turn around and flow down those clauses to your subcontractors. again, not floating down the clauses can be its own violation of the clause itself, which is a bad thing. There we go. And so, and what are the remedies? The remedies here, because we're talking about contracting with the government, can be a little more severe and a little more economically threatening in some respects. Yeah, there's liability for back wages and fringes. There's some withholding of payments. The government can withhold payments, contract payments to the prime contractor, who then withholds payments from the subs down the road. Federal government can terminate a contract for non-compliance with some of these labor requirements. And then we start getting to the death penalty of government contracting, debarment. If that's usually reserved for the worst case scenarios when a contractor does really bad things, and the government will put you on the naughty list and not do any business with you for up to 3 years. And even worse, something called False Claims Act. False Claims Act says if you lie to the government or you make a false certification in exchange for seeking payment, and the government catches you, the government can turn around and sue you for triple damages, seek criminal prosecutions, and do all kinds of other nasty things. So we don't want to be doing any of that stuff. So that's part of the reason why we have this conversation today, to keep everybody on the straight and narrow. So let's start off with the topic of affirmative action plans and OFCCP audits. Let's go to the next slide. There we go. All right. So what is the OFCCP? It's the Office of Federal Contract Compliance Programs. It's a subsection, a sub-office in the U.S. Department of Labor. And it's an add-on layer. It sort of deals with EEO-type issues for federal contractors. And we'll get into that in a little bit. But you have to comply with regular Equal Employment Opportunity Commission requirements. And then on top of that, deal with the OFCCP. The two agencies frequently work in tandem and work side by side. But OFCCP has its own requirements. So what does the OFCCP do? It enforces and regulates federal contractors and subcontractors, primarily arising from 3 different regulatory schemes. First, there's an executive order that dates from the 1960s, Executive Order 11246, that definitely prohibits discrimination based on race and gender. Then there is Section 503 of the Rehabilitation Act of 1973, which prohibits disability discrimination. And then finally, they have the Vietnam-era Veterans Readjustment Assistance Act, otherwise known as VEVRA, which again prohibits discrimination against veterans. So what do you have to do for all this stuff? Now we have the 3 different regulatory schemes. What's required? Well, typically, none of these things are overtly hard or complicated. It just requires some planning and some forethought. So first off, you have to include equal opportunity clauses in contracts and subcontracts, as we discussed earlier about flowing down the clauses. Next, you have to publish notices and post notices on EEO policies, both internally and externally. Basically, you want to let your workforce know that you abide by certain equal opportunity policies, and also publish that in any job announcements to the public. There's, in addition, the next item here, there's mandatory record keeping. Again, it's similar to what you would normally have to do as a sort of a commercial business, but there's some added little twists about what the types of information you have to keep and where you have to keep and how you have to make it available to the government if and when you get investigated. Then what we're going to talk about a little bit is developing and maintaining an affirmative action plan. That is a living, breathing document that you create about once a year. It involves a statistical analysis of your workforce to determine what the demographic makeup of your workforce is, and whether and how much it differs from the demographics of the region in which you have your offices. Because again, the government doesn't want you to have an all old white guy workforce when in fact you live in a diverse geographic area where there's a lot of geographic and demographic diversity. They want to sort of mirror where you live and where you work. And along those lines, you have to conduct purposeful outreach and recruitment of women, minorities, disabled, and veterans in order to try to increase the number of applicants so you have a better choice of applicants to be able to hire people to better reflect the demographics of your area. There's also going to be training that you have to provide on a regular basis, similar to what you would do for normal EEO training. In addition, there's going to be required reports that you have to file with the federal government. EEO-1s, which I'm sure somebody this afternoon is going to talk about. But then there's a report called the VETS 4212 report, which has to be filed concerning discrimination regarding veterans. And then finally, all this stuff that we talked about is subject to compliance investigations and audits by the Office of Federal Contract Compliance Programs. So, there we go. All right, so what kinds of businesses are impacted by this? Well, pretty much anybody who has a contract with the federal government or a subcontractor working for a prime contractor is going to be touched by this. When we're talking service contractors, includes contractors working for hospitals, includes banks, manufacturers, construction companies, prime contractors, and as I said, subcontractors of various tiers to the extent they're doing work on the federal contract. So what is a covered contract for OFCCP purposes? Again, it's easy when you're talking about the prime contractor because you entered into a contract with the federal government. You got the clauses, the non-negotiable contract clauses that you're agreeing to in exchange for providing the services or the goods so that you get the federal government's money from the full faith and credit of the federal government. So that's easy. But then the question becomes, at what tier subcontractor do you have to comply with this stuff? And it really depends. Typically, if you're doing any work in support of the main purpose of the contract, that subcontractor is going to have to also comply with OFCCP requirements. And it could be at any tier of the supply chain. From the company that produces the fighter jets to the company that makes the little knob that gets attached to the fighter jet. So it all levels. So after you do all this background and basic compliance stuff, what could happen? Well, the OFCCP typically does an audit of prime contractors, all prime contractors, about once every 2 to 3 years. And the OFCCP sends out for service and supply contractors, not construction, but service and supply contractors, they send out what's called a corporate scheduling announcement list, or CSAL list. It's a wonderful thing. The OFCCP publishes a list of all the contractors it intends to audit in the next 6 months to a year. This list is made public. You can find your company's name on the list. You go, okay, great, we're on the list this year. What do we need to do? What do we need to do to prepare for this thing? It gives you some lead time to get your compliance house in order, to get your documents together so that when one does get the scheduling letter and the itemized listing, which we'll talk about in a second, you are in a position just to say to the OFCCP, here you go, here's my stuff, have a nice day. So after an audit investigation, assuming there's a problem, and look, most contractors who do this stuff, at any tier, no contractor is perfect. Every contractor I've ever dealt with has some little minor hitch, and because again, you're dealing with people, you're dealing with personnel issues, there's always a twist or turn somewhere. So no one's perfect, but we try to help you get there as much as possible. So what are the remedies in case something goes wrong? As we discussed before, typically if you're talking about EEO type issues, there could be a make-whole remedy for hiring compensation, require order back pay, maybe some preferential hiring to the extent there was some perceived discrimination in promotion. If there's some real big problems, then the OFCCP could recommend that the federal contract or your subcontract could be terminated, or you could be suspended from doing work for the federal government. Or even worst case scenario, if there's something real horrible and malicious about it, you could be put on the debarment list. And to the extent that your company is reliant on federal contract work, that could be a death sentence for a company. So we try to avoid that as much as possible. So how do you help avoid some of these remedies, and how do you avoid the boogeyman of the OFCCP? Well, as we talked before, a good, robust development of an affirmative action plan on an annual basis, because you want to have the good demographic data to analyze the demographics of your workforce on an annual basis, prepare the analytical framework run reports, figure out which demographics are being underrepresented, which demographics are being overrepresented, and to make purposeful efforts to do recruitment to try to address those inequalities. So that's good affirmative action plan development and enforcement is key. Next, as it's certainly for prime contractors with the federal government, one has to file a certification with OSCCP on an annual basis as to compliance. Now, this is where OSCCP gets a little tricky because they just started doing this about a year or two ago. And by certifying compliance with OSCCP requirements, that potentially puts contractors on the hook for False Claims Act liability if they certify something that's not true. So again, before you certify something, you want to make sure that you can say with a very straight face that you have complied with OSCCP requirements. Next, we talked about reports and just helping a contractor through the audit process, which can be a little tricky at times, because when a government investigator comes knocking on your door asking for documents information, companies that haven't dealt with the Department of Labor before have, in my experience, have a tendency to say, here, take whatever you want. We're an open book. It's never a good strategy to let the government go walking around and see whatever they want. Always much better to have work with counsel to try to find a way to narrowly tailor what you provide to the government so that they only see the snapshot of information they need to see in order to address the regulatory issues that they want to address. So let's talk about some recent developments in the OSCCP world. Again, we talked about the CSAL letter. The OSCCP changed its methodology for how it creates the CSAL list, what contractors it puts on the list, and the most really relevant piece for today's discussion is that OSCCP is committed to sending out CSAL lists twice a year. As you see in the bottom note here, OSCCP sent out a CSAL list for service supply contractors back in June, and plans to do so again before the end of the government fiscal year on September 30th. Again, this is an invaluable thing. Go look for it. Go see if your company is listed there, which facilities your company is listed, and start taking proactive action to get in compliance for when you do get the letters. All right. So, to speak about the letters, you're put on the CSAL list. That by itself is not the kiss of death. What happens is that eventually OSCCP will send your company a scheduling letter. Say, okay, great, you've been on this list. We want to schedule an audit with you. We want to look at your records. We want to conduct some investigation. Great, let's do this. And so OSCCP has beefed up the type of information it wants as part of the scheduling letter and itemized listing. They're asking for more detailed information. They're looking for more analysis. They're looking for more certifications. And so it becomes a little more of a statistical process to work through as a result of these new changes. And then finally, OSCCP on the back end, assuming they do an investigation and they smell smoke and they think there might be an issue, they have these expedited conciliation procedures, which says, okay, great, we think there might be a problem here. Sign this agreement and agree to take these certain corrective actions, and then we'll leave you alone for 3 years. Well, it could be good, it could be bad. The devil's in the details. The conciliation agreements are pretty standard, but some of the requirements could be potentially onerous depending on your company's situation. So always good to carefully analyze the situation before agreeing to these things, even though it may be administratively easy just to sign it and move along. So let's change topics completely. We talked about OSCP. Now let's talk about prevailing wages. And again, as I said, most of this stuff deals with contract clauses. This is just a short listing here of the relevant federal acquisition regulation contract clauses that deal with Davis-Bacon Act prevailing wages that apply to construction. Again, we're talking about construction for every federal contract in excess of $2,000 for the construction, alteration, or repair of public buildings or public works. This is what's going to be required here. So look for this in your government contracts or your subcontracts that you get from your customers. So these prevailing wage requirements are everywhere. There are about 70 federal statutes that implicate this. I listed a couple here on the screen. Also, Davis-Bacon Act prevailing wage requirements also kick in for federal grants that have a construction component. And then finally, where this really gets interesting, is that in the Inflation Reduction Act, if you want certain tax credits now, you have to comply with Davis-Bacon Act Light as administered by the IRS, which is a whole nother discussion for another time, but a lot of what we're discussing here is going to roll over and impact that. So what's the big deal with prevailing wages? Well, this is a snippet from the contract clause here. And basically the highlighted stuff is the important stuff. Basically, all laborers and mechanics, basically being construction workers, have to be paid unconditionally and not less often than once a week the full amount of wages and bona fide fringe benefits at rates not less than those contained in the wage determinations. So let's break that all apart here. So paying once a week, that's easy. What's a wage determination? Wage determination is created by the Department of Labor's Wage and Hour Division. They have a government contracts branch, part of the Wage and Hour Division. And part of their mission every year that they go around the entire country, county by county, state by state, and they do wage surveys. They find out what the prevailing wages are for construction work in every county and location across the country. Typically, it's keyed off of collective bargaining agreement rates, because the Department of Labor primarily looks at CBAs, but also going to be surveys of employers. And they come out with 4 different types of wage determinations based on the type of building that's being done. I'm going to talk about just general building, but they also have residential, highway, and heavy construction like dams and big power facilities and stuff like, and roads and things like that. So what is a wage determination? Well, again, if you're curious, you want to look and see, go to sam.gov here, like I have on the page. It's a public website run by the federal government. And you plug in sam.gov, and this page will pop up on wage determinations. And you can click there, and you can scroll through, and you click on the public building, and you'd say, okay, great, show me the wage determinations for Washington, D.C. That's where I'm from. So I plugged it in, and voila, this is what pops up. This is an August 2024 wage determination. Like I said, these things are updated annually, semi-annually by the Department of Labor. And you'll see it has various wage determination numbers and versions and all that stuff. To the extent you're getting ready to start work or you have a contract, you want to find the correct version, the correct wage determination number, and see what it says there. Should be attached to your prime contract, should be attached to your subcontract, but if not, you can always go online and find it. And then scrolling down, these wage determinations could be 5, 10, 15 pages long sometimes. You're going to have a listing here of all the different job classifications on the project, and bricklayers, electricians, plumbers, everything here. And you'll see this is just a short snippet from the Washington D.C. one, and this is what Department of Labor has deemed to be the prevailing wage rate for these job classifications in the D.C. area. And you'll notice there's a rate and there's a fringe. The rate is the hourly wage rate. The fringe is the cash value of the fringes that must be paid. And so the contractor has to be sure to pay both the wages and the fringes weekly, pursuant to the Davis-Bacon Act. As I said, it has to be paid for all time spent in each classification. To the extent you have 3 guys on a construction project, and the guy is working as a plumber and as a bricklayer and as an electrician all on the same day, well, guess what? Now you have a really complicated situation because you have to pay that one employee for the time they worked in each classification during that day. You can't just average it all together. You could pay the highest rate if you wanted to. The Department of Labor will never fault you if you pay the highest rate to an employee. But to the extent you have people working in 3 different classifications, you can't cheap out and pay them only the lowest. You got to pay them for each one. And there are also special rules for dealing with apprentices. Apprentices can be paid if they're in a registered apprenticeship program. Apprentices can be paid a percentage of the wage, but they still have to be paid the full fringe. So again, now this is complicated, but you just have to be aware of the rules and make sure that things are followed properly. Now, the added feature to these prevailing wage requirements is that, there's typical Fair Labor Standards Act record-keeping requirements, but expanded categories of information have to be kept, such as the classification, the hours spent in each classification, as we just discussed. So I mentioned fringe benefits before, and it has the wage determination has an amount of the cash equivalent. So the easiest thing for employers to do is just simply pay the wage rate and the fringe all as cash, and add the two numbers together, and that's the hourly